matter to come before the court this morning is about Justin Evans versus State of Ohio. Each party is aware will have 15 minutes in which to present the case. If you're the appellant and you wish to retain up to 5 minutes for rebuttal, you may do so. Let me know when you come up to the podium. I'm keeping track of the clock and keep you apprised of the passage of time. We are being visually and audibly recorded and we posted online, so please try to remain by the podium as much as possible. We have read your briefs and are ready to proceed when you are.
Thank you very much, Ron. Proceed.
Yes.
Thank you. Good morning, Your Honors. This is the first time I've been here. My name is Jeff James. The court is aware I was appointed to represent the appellant in this case, Justin Evans. This is a case involving a case where Justin Evans was charged with aggravated burglary. He proceeded to a bench trial in this case, and he was found under these facts to be guilty of aggravated burglary by the court, and was sentenced to 5 years in prison. And we can talk about it because we'll ultimately get to probably, if you're interested, I mean, you can read it. The fact of this case, this is one of the most interesting aggravated burglary cases I've ever seen, or more unusual ones. But what really was of concern in this case, in looking at the trial transcript, was the fact that because there was a co-defendant, and that was his wife, who was an assistant manager at the Taco Bell, because there was a co-defendant in this case, then let me just get that, Ashley Morris, who apparently somewhere in the day or so before trial had decided to plead out, enter into a plea agreement with the state, plead out for community control, and agreed to testify against her husband, Justin Evans. As a result of that, on the morning of trial, as he apparently learns this, and understand they had already filed, it probably was based upon these facts, they filed a waiver, jury waiver, and he was represented at that time by attorney Nathan Ray, very good, qualified attorney, and they had filed a waiver of jury and had anticipated going to a bench trial at that point, so it's not any issue. But on the morning of that bench trial, upon learning that Ashley was going to be testifying against him, Justin Evans decided that he wanted to represent himself. Every indication seems to be that he wanted to represent himself because he thought he would do better in cross-examining his wife, Ashley, than anybody else would, that she was not in a position, that if he was cross-examining her or questioning her, that she would not lie. That was his rationale, and I think that's clear on the record. At that point, Judge Breaux went through the process, and this was rather hurried, understand, because this is the morning of trial, of the process of, do you understand what is required of you in deciding to represent yourself and to waive your right to counsel? It is my position that in reviewing this, that the court did not engage in the proper colloquy that is necessary for a waiver of trial, or waiver of counsel. We all know that under the Sixth Amendment, you have a right to counsel. You also have a right to self-representation. But this court was very clear in the case of State versus Trachillas. And it may be one of the better cases as far as setting forth in detail exactly what must be done by the court in advising a client that you understand the pitfalls of representing yourself at trial. And Trachillas basically goes through that there's no one dispositive factor. The trial court should consider whether the defendant was advised of the nature of the charges, the range of allowable punishments. In addition, may consider whether the trial court advised the defendant of the possible defenses to the charges and applicable mitigating circumstances. There was nothing in here with regard to, and understand, I'm sure the state in its brief is saying, well, there was negotiations earlier. It appears that somewhere unrelated to this colloquy that was performed in waiving your attorney, it was somewhere else in the record indicate that he may have had some knowledge as to what the potential penalties are. Okay, let's grant you that. You know, I think it should be put together, particularly when someone's waiving counsel. Are you clear now? Do you understand? This is a F1 felony. You're facing a potential 11 years in prison if you waive counsel and you are found guilty by this court. But more importantly is that there's nothing in there other than indicating to him that you understand that you don't know the rules of evidence and that's going to be problematic for you. There's no indication that there was anything about what are the elements of the offense, what are the potential defenses to this case, or to this, what are mitigating circumstances that you can bring up in cross-examining. There would have been, I think, if Nathan Ray had represented him in the course of this trial, there probably would have been a lot more emphasis on 2 points in particular. One is there a trespass here? They gained entrance using her key. And while there's some conflict, it also appears that there is gained entrance with the understanding that he was going there, that there were some calls there, that they were going there to get food, even though it was after hours, that there was telephone communications with his former girlfriend and the former friend of Ashley Morris. You could have had explanations about, you know, the elements of the, which should have occurred, elements of the offense, and you understand that the issues that you may need to focus on are issues, do we have really trespass? And secondly, do we have, you could address more clearly, physical harm. There's no question there's some shoving and pushing and things of this sort, and he did testify, that was the manager, Angelo. He testified that he sustained, you know, I think some bruising injuries of that effect, you know, and I think that would, of course, is the basis of physical harm, giving rise to the aggravated burglary. But it's our position that this court was required to do a lot more than what it did in that short period of time in going over what is important about having qualified counsel and what the pitfalls are of waiving counsel and what are the potential penalties, what are the possible defenses, what are mitigating circumstances that you need to consider, what should you be doing if you're going to represent yourself. And this court set the rules out. It's your rules. Terkellis is clear about what has to be done, and that wasn't done. In light of that, this was not a knowing, voluntary, and intelligent waiver of counsel. And if that's not the case, then this should be reversed and sent back to the court. With regard to the other ones, assignments of error is just a sufficiency and a manifest weight argument. I would just ask the court to consider the facts in this case. I mean, I understand that you can argue that technically, very technically, we may have the appearance of all the elements of an aggravated burglary. No question it appears that they gained access to this Taco Bell using Ashley's key. Thus, it doesn't appear that, at least initially, there's any trespass. The only way you can create a trespass is the fact that Angelo, the manager, which I don't know what the relationship was, but as far as the knowledge of Justin Evans and Angelo, I know that Ashley knew who Angelo was, but there's no indication in the record as to exactly that Justin Evans knew that he is the boss, he is her boss, he is the manager of the store. He just happened to be there saying, you guys can't be in here, get out of here. So we create a trespass at that point in this premise. And then we get into this altercation between everybody at that point, and every indication is that it's this juvenile who starts the altercation, and only after Angelo gets into a process of pushing this juvenile and getting into an altercation with the juvenile, does Justin Evans come in, and apparently it appears to be to the defense of this juvenile, and there's an altercation between Justin Evans and Angelo, the manager. So if you take it step by step, do we really have this kind of concurrence of the necessary elements for aggravated burglary? And do we, under the facts of this case, is this really where we want to be pursuing aggravated burglary charges and sending someone to prison for 5 years on facts like this?
Counsel, we get cases like that sometimes, and one of the things I always think of, though, is isn't that the decision of the prosecutor if it meets the elements?
Yeah,
And
I
people
kind
let
of
the prosecutor.
understand that. And, you know, just as just kind of an editorial comment, because I know that I often get that with prosecutors, that, you know, I'm just following the legislation. This is the, you know, if you have an issue with that, bring it up with the legislature. My response to all that is always, you know, and this is, I know it's terrible, but, you know, that was the same defense they used at Nuremberg. When you start thinking about that, you know, we are supposed to do the right thing. We are supposed to seek justice. In this case, under these facts, we just sentenced a man to 5 years in prison under these circumstances and these facts. Should we all be concerned about that? I would hope so. You know, I'll reserve a couple minutes in rebuttal. I'm not sure that's really necessary. Surely this court is going to take it into consideration. I think that the stronger argument here, I understand that technically it appears that we have the necessary elements met if you interpret all the evidence in such a way that there was indeed a trespass once Angelo said, get out of here, that that Justin Evans should not have participated in a fight, and it's really unclear as to whether he actually initiated it or he was coming to the rescue of this juvenile, all right, with Angelo and causing this injury to Angelo, and then we have some injury to Angelo based upon the testimony of Angelo. Because I don't see anywhere that there was any medical records introduced to indicate that there was medical treatment of Angelo.
Counsel, did the state have, and this is to your sufficiency argument, did the state have some evidence that prior to this incident, Mr. Evans had been told not to come back to that Taco Bell, or did I totally misread something, which is certainly possible?
No, I have there's nothing in the record indicating that Angelo had any knowledge that he was not supposed to come there.
Okay.
In fact, I don't think there's anything in the record. I mean, it could have been, if he had had competent counsel, it could have been explored with Angelo on the stand. I don't think there's anything in the record indicating that he even knew who Angelo was. I mean, he knew that his wife was an assistant manager. He knew that Jennifer was another assistant manager. I don't know that they necessarily knew that Angelo was the manager above them. So when they arrived there, going in there under whatever purposes, possibly to get food, possibly to have contact with Jennifer, whatever, because that's kind of, it's all over the place on that issue in the record. But there's nothing to indicate that he necessarily looked at Angelo and said, okay, you have more authority than my wife does as far as whether I should be here or not. Because she has a key. We came in with a key. Those all could have been explored if there had been competent counsel. But there wasn't. Thank you.
Good morning, and may it please the court. I'm Jacqueline Corrigan, and I represent the state of Ohio to urge this court to affirm Mr. Evans' conviction. Mr. Evans did knowingly, voluntarily, and intelligently waive counsel in this case. And getting to some of the points that counsel raised, he mentioned that Mr. Evans' decision to proceed pro se was spurred on by the announcement that his wife, Ms. Morris, would testify on behalf of the state. Just a point of clarification, the possibility that Ms. Morris would testify on behalf of the state was known to the defendant and his counsel long before the trials, a few weeks at least, but the certainty that she would testify was not there until that morning. However, this is the kind of error or the kind of consideration that the trial court has to look at the totality of the circumstances, and is not required to give a rote recitation of any particular test. That's pretty clear from the Ohio Supreme Court's decisions in Johnson and Obermill. No rote colloquy is required. But yet, if the totality of the circumstances before the trial court indicates that the waiver of counsel is made knowingly, voluntarily, and intelligently, then there's no error. And even the lack of a written waiver of counsel is considered to be harmless under those circumstances. And the totality of the circumstances before this trial court showed that trial court that Mr. Evans was knowingly, voluntarily, and intelligently waiving his opportunity to have counsel. It's clear from the record that Mr. Evans had a prior record. In fact, he was out of prison for less than 6 months at the time when this offense occurred. He had been represented by counsel for months. Prior to the trial, about a month before the trial was scheduled, Mr. Evans filed his own pro se motion to dismiss this case, in which, even though the copy that's in the docket is not terribly clear, it appears that he was challenging the factual basis for the charge and the elevation of the original charges in municipal court from assault and trespass into an aggravated burglary. He was challenging that, the factual basis for that. He cited sections of the revised code. He even cited evidence rule 401 regarding relevancy, and was charging the very basis of the charges against him. So the trial court, having seen that a month before trial, could take that as an indication that Mr. Evans certainly knew the nature or understood the nature of the charge against him, certainly enough to raise his own pro se motion to dismiss it. Then on the morning of trial, yes, he decided to go pro se on the morning of trial, but that was after a discussion with the court in which counsel for Mr. Evans actually told the court that he had discussed this with Mr. Evans, that Mr. Evans understood what he was about to undertake, that he would have to be responsible for conducting the entirety of the trial, from opening statement to closing argument, all the objections, all the examination of witnesses, et cetera. And that is at pages 15 and 16 of the transcript. In addition, the trial court reviewed with Mr. Evans the fact that he didn't know the evidence rules, that he was at a distinct disadvantage, that because he didn't know the evidence rules, he doesn't know how to object, he doesn't know how to do it, when to do it, how to oppose an objection if the state raised one. And that, by the way, is after Mr. Evans requested and was granted a quick recess to discuss the issue again with the counsel that had previously been appointed for him. And after discussing it with counsel, the court engaged in that discussion with him. And again, like I said, the court did give him a recess. Talk with this, about this with counsel, and he did. And still, after that and after all that, the court confirmed with him that yes, he still wanted to proceed pro se. And this is not one of those cases like the case in State versus Ott, which was before this court, which Judges Carr and Judge Schaefer heard, or State versus Clark, which was recently decided by this court. Again, with Judge Carr and Judge Schaefer, hearing that. For instance, in State versus Ott, Mr. Ott got basically nothing concerning the disadvantages he would face other than you're going to have to subpoena your own witnesses and make sure they're here for court. He was left to fend for himself. In State versus Clark, we had much, much more serious charges than we're facing, even though this was a felony of the first degree, much more serious charges that were facing Mr. Clark. He had multiple counts of rape of a minor and gross sexual imposition with a sexually violent predator specification, which ended up putting him in prison for a 25 to life sentence. So those were much more serious charges, and as the Ohio Supreme Court has indicated, the level of offense and the seriousness of the charges and the seriousness of the sentence that a person could receive needs to inform the trial court's discussion with the defendant as to how much they understand their right to counsel and the need for competent counsel.
An F1 is pretty serious, isn't it?
It is indeed, but it's in light of the potential penalty, maximum penalty of 11 years versus a life sentence for a rape of a minor. One could argue that that's a more serious charge because of the more stringent and lengthy penalty.
Counsel, you mentioned some things in your brief. One thing, the pro se motion you had filed.
Correct.
I had no indication that the trial court relied on that in any way in terms of how legally astute Mr. Evans may or may not have been. Is that a fair statement, that it didn't come up during the sentencing?
That's very fair, that it did not come up during sentencing. And in fact, the trial court could not have actually ruled on it because Mr. Evans was represented by counsel at the time that he made the motion. However, it certainly would have been on the court's docket, it would have been before the court, and that would be an indicator as to his competence to represent himself. Just as in the Yeager case, Mr. Yeager indicated to the trial court, even though that was in an actual discussion with the court on the record, that he had been pro se in several other proceedings in the past. But that was one of the factors that the trial court could consider.
And the discussion about him staying in Orange because it wasn't a jury trial, was that before or after the decision to allow him to go pro se?
If I recall correctly, correctly, it was after the decision to go pro se.
Thank you.
As to counsel's arguments concerning assignments of errors 2 and 3 concerning sufficiency and manifest weight, just very briefly, Your Honors, I would submit that the state did present sufficient evidence concerning each element of aggravated burglary, and that it was not against the manifest weight to find Mr. Evans guilty of that offense. Concerning the element of that we have an occupied structure in which a trespass occurred, there's really no reasonable dispute that when you have at least four employees in a restaurant, that's an occupied structure. As far as trespass, the record is that Mr. Evans had been previously barred from entering the restaurant because of the dispute that he had going with the manager, JJ, who I'm referring to by her initials because she testified that she was afraid that he was already barred. It's really immaterial as to whether he knew who Mr. Kouzoulis was, although there's an indication that Ms. Morris had to go to the store to drop off paperwork to Mr. Kouzoulis to show whether she had an absentee that was excused. So it's really not terribly clear from the record as to whether he knew who Mr. Kouzoulis was, but clearly that's an employee at the store who's supposed to be there. You know, if Mr. Kouzoulis was working, he was supposed to be at that store. And when you have a Taco Bell employee telling you, get out, at least 3 times, that's an indication that you're there without permission. And that's part of the trespass, it's not just knowingly entering a place where you don't have permission to be, it's remaining there when you don't have permission to be there. And Mr. Evans was told by Mr. Kouzoulis at least once, and certainly the teenager was told twice in Mr. Evans' presence that they were supposed to leave. By forced stealth and deception, the case law establishes that opening even an unlocked door is considered to be force, and Ms. Morris' keys were used to enter a locked door. For a building that was closed, locked, employees were not permitted to leave, and certainly no member of the public was allowed to come in. With purpose to commit a criminal offense, that's the next element, Ms. Morris testified that the sole reason that they were there was for Mr. Evans to confront JJ. And by Mr. Evans' actions in pointing out JJ to the teenager who accompanied them, and then the teenager going and immediately going and throwing 2 punches at JJ's head, one can infer from Mr. Evans' actions in pointing her out that he intended for that teenager to commit that offense. As far as physical harm being inflicted, the teenager certainly inflicted harm on JJ, and both Mr. Evans and the teenager, Mr. Kouzoulis, testified that both of them were striking him. Finally, it must be remembered that yes, the teenager was the one who took the keys and entered the building, and the teenager was the first one to throw punches, but Mr. Evans can be complicit in that offense, and it doesn't have to be charged separately. And by complicity, we do have testimony in the record that Mr. Evans actually picked up the teenager at Chapel Hill Mall after hours to take him to the Taco Bell, so he was soliciting or procuring another to commit the offense that Mr. Evans intended to commit. As far as the manifest weight, there is good reason for the trial court to have found the proffered versions from the defendant as to what happened not to be credible. For instance, there was more than one version of the story that Mr. Evans and Ms. Morris told. Those versions kept changing. Ms. Morris came in and testified in court that those versions of the story, prior to the one she was telling at trial, were versions that Mr. Evans created and that he directed her to give to police and to his parole officer. Furthermore, it was common knowledge at that Taco Bell that Mr. Kouzelis was never there on a Friday night. This was a rare occasion when he was there on a Friday night. And that gets to the explanation of, well, Ms. Morris was there at the store because she was supposed to take paperwork to Mr. Kouzelis. Nobody expected him to be there. So that shows that reason does not fit the facts. And furthermore, as far as the explanation of, well, you know, JJ called and said that we were supposed to pick up food, that dining room was not supposed to be open after 11. The drive-through, however, was open. Had they been there truly to pick up food, they could have waited in the drive-through line like everybody else who was already in line, with other legitimate customers who were to go and pick up food through the drive-through window. So that shows that explanation doesn't actually fit with the facts either, and the trial court could have discounted it as not believable. So the state of Ohio submits that the conviction was indeed supported by sufficient evidence and was not against the manifest weight of the evidence. And as I suspect that I'm coming to the end of my time, unless the court has any other questions, the state of Ohio would respectfully ask to rest on its brief and ask you to affirm. Thank you very much.
Thank you. Well, I didn't specifically reserve it. I do believe I have a couple minutes left.
3 minutes and 47 seconds.
I will be happy just to do it in 2. And it's really just addressing, Your Honors, the issue of the waiver of counsel. The state indicated to the court that Mr. Evans filed certain pro se motions. They're in the record. You have the docket. The court, of course, whenever there's a situation where you have counsel, Nathan Ray in this case, being appointed, and there's pro se motions being filed, doesn't consider those pro se motions because we do not permit hybrid representation, and we're just going to ignore it. But we're still there because if the clerk of court receives it, we're going to file it and docket it. Feel free to look at those. Do we have any indication that this is a man that, you know, was making cogent arguments in those pro se motions and fully understood the ramifications of self-representation? I would submit to you that no, that's not what those indicate at all. And the other point that the state made is that there was in the record that he spoke with his attorney, appointed counsel, prior to coming back into the court. There was a break. Coming back into court indicated that he wanted to represent himself. They want to ask you to infer that that counsel at that point went over all of the ramifications of self-representation, and that they did that, you know, as adequately as the court could have or should have done it. If that's the case, then why do we even have sentencing? Why don't we just have the counsel go out and explain to them that this is the possibility of post-release control, this is the possible, possible sentences, you understand that, you understand the constitutional rights that you're waiving, you understand all that. Your Honor, I have advised him of everything that I need to advise him of. There was really no reason for this court to go through a plea colloquy because it's just an exercise of futility since he already knows.
But the difference there is, obviously, is the case law talks about whether someone waives their right to counsel as a case-by-case determination.
In the case law, real clip.
There's not specific rules, you have to do it this way.
And interesting, there is a rule. I agree that to some degree the courts have abrogated it, which I find interesting. I love how we create rules and then we abrogate those rules by decisions. You are supposed to have a written waiver of counsel. That was not done in this case. So similarly to, we do have rules that the court must engage in a plea colloquy. Similarly, we have rules that they should have a written waiver of counsel. That was not done in this case. We did engage in a colloquy of some sort, but it's inadequate. And under the circumstances, particularly the facts of this case, Mr. Evans would have done a lot better with trained counsel. I don't think there's any question about that. But instead, he was convicted and he's serving 5 years. As to his prior sentences and prior convictions, what relevance does that have to anything? You want to start judging people on their past?